Hello and welcome to this edition of Enterprise Matters. I'm Vinod Kumar, your host for the evening. And today we are going to discuss a very important topic about the draft digital competition law. Um, and we're going to discuss the various provisions in the draft law, the implications for micro, small, medium enterprises, and its various issues. One of the things that we have been discussing earlier also has been about the European digital law and the various other laws that have come into force in various territories, and some of the ex ante regulations, and the need for a balanced approach, whether the law is going to help prevent monopolistic behavior or promote fair competition, and what are the challenges and opportunities for micro, small, medium enterprises uh, as far as the digital economy, the new knowledge economy goes. We are going to be joined by a very well known group of people that are experts in this entire arena. I'm going to be joined by, first of all, Professor Vishwanath Pingali. Professor Pingali, we all know he is part of the IIM Ahmedabad. Welcome, Professor. Thank you for being here.
Hi, Vinod. Very good to
Very
see
much.
you.
Pleasure is all mine. We are also going to be joined by Shreya Suri. I don't. Shreya, are you there? Shreya is the partner at Induslaw and recognized as a recommended lawyer. So welcome, Shreya. And
Hi.
thank you. We sometimes able to see you, and sometimes you are merging into the background. So,
I
but
do
nevertheless,
apologize. Let me see what I can do about that. But lovely to be here and thank you for having me.
thank you very much. We are also going to be joined by Meghna. Meghna is the director at Esya Center. She's also a lawyer. She's got a varied background of legal and policy strategy at various companies. So, welcome, Meghna.
Thank
Thank
you
you for
very
being
much for
here.
having me. Yeah, thank you very much for having me.
Pleasure is all ours. So we are going to go directly onto the conversation for today, and most of us are aware of the fact that there is a draft um, law that has been put up for comments by the ministry, specifically for gathering information, comments, perspectives from the public. So our discussion today is going to be focused just around that. I'm going to go over first to Professor Pingley and check with him. Professor, we're talking about this draft law, and some of us have this feeling that it's going to have a significant impact on the micro, small, medium enterprises of India. Can we have your initial comments, please?
Sure. Thanks, Vinod. As I said, thanks for having me in the first place. It's always a pleasure to talk to you and the group. So let me summarize my views on it, and I'll also explain some of the research that we've been doing and we intend to publish in this area. What is the advantage that platforms bring to the table as far as small and medium enterprises are concerned? The first element, obviously, digital platforms have always been looked up as avenues where they reduce transaction costs. You live in one corner of the country, I live in another corner of the country. Connection happens between both of us, and trade happens between both of us with minimal amount of fuss. So that's a first advantage that you see platforms bring to the table as far as small and medium enterprises are concerned. In a recent survey that we did of close to 1,400 small and medium enterprises, we noticed that those firms which are active digitally on advertising and active digitally in terms of using logistics serve in greater geographical regions, and they tend to export more than the firms that don't actually. So that's the first thing. There's another classic advantage that platforms bring to small and medium enterprises. That's an element of trust. This is an ongoing work, literally. So therefore, this is semi-cooked work, but nonetheless, I would like to put it out there. It's an element of trust. So imagine I order something from you, then you send me something which is not authentic. Me taking you to court is one such thing. But me going and complaining to the platform and the platform rectifying the situation is another thing. Depending on the legal situation in the country, the platform's role as reducer of transaction costs versus, versus the guarantor of trust keeps changing. And I think in India, it's a combination of both. It's not a single thing alone. In a more advanced economy where legal system is fairly robust, I would actually think it's a reduction of transportation costs. So now let's actually, with this background in mind, let's parse some of the elements. When you're putting a blanket ban on bundling and tying services, which is one of the essential parts of the bill, on the prima facie, something like this is supposed to improve competition. But then if some part of a transaction goes kaput, so for instance, I order a laptop from vendor and he or she sends me a cartload of trash. I've been repeating this example so many times because this literally happened stone's throw away from where I was sitting because one of my own students had to go through that experience. Make sense? Now, which part of the supply chain would you blame this on? If let's say tying and bundling exists and I relied on a platform, both for my advertisement and all that stuff, I know exactly where I discovered the seller of laptop as well as the one that transformed to me. I know where to put the blame on. I'll go to the platform and I'll basically argue with the platform XYZ. And this is where, to me, a significant amount of advantage the platform brings to the table. So therefore, to me, some of the elements of the current bill affect on the trust part of it, even if they're attempting to reduce the transportation cost. Let me argue some more. Imagine that you, once again, are trying to unbundle. Let's keep the trust aside and let's go back to the transportation cost world itself. I am a platform, I'm a business. My duty is to make profits. When you're not allowing me certain service, I will jack up my markup in some other service. And that's pure economics. And that's pure microeconomics competition we all talk about everywhere. So therefore, what's likely to happen is will the consumer's transaction costs eventually, or the system's transaction costs eventually reduce in the market? That's anybody's guess, actually. So therefore, to me, the fundamental question in terms of impact is some of the presumptions that were made while this bill is being talked about or it is being drafted is that it is contingent on several assumptions. And these assumptions need to be validated using data. So therefore, to me, that's a fundamental point. And the second thing is that, they're acknowledging the fact that one shoe fits all solution is not correct. So therefore, they're going to do case by case basis. This is amazing on one side of it, right? Because of course, you're going to do case by case basis. But how are the cases going to be determined? I think the parameters on which these are going to be judged have to be proposed much in advance, because otherwise, case by case is going to add to policy uncertainty and nothing else. Who suffers in policy uncertainty? It's the small businesses, unfortunately, that take greater brunt of policy uncertainty than the big ones. The big ones figure out how to survive. It's the small ones that have a problem. So therefore, on multiple levels, I do see some problems. Therefore, while I see that they've extended the time for public opinion and all that stuff, is it sufficient? The answer to me is no. I mean, I'm looking at Meghna. Every time she goes first, she speaks most of her points. Today, I think I spoke most of it. This is the competition, right? I mean, there's a great balancing act that it does. Over to you, and I'm happy to come back in later.
Excellent. No, that was perfect. In fact, I was going to go over to Meghna because, I wanted to know from her, the fact that you have the DCCB released a draft released. Is there a need, basically, from the if there is there a need to regulate digital markets at this point in time, specifically when we are looking at this entire digital economy, I think growing, fledgling economy, wherein micro, small, medium enterprises are trying to figure out ways and means of how to work, what to do. And there is unique, I'd say, challenges as well as opportunities in the way digital markets are behaving specifically today. So, Meghna, your perspective.
Yeah. So let's think about the context in which the DMA has been introduced, right? One reason why the DMA has been introduced, and while the European Commission will never admit this, but there's enough scholarship to support it, is that the GDPR, the General Data Protection Regulation, created a significant market failure in the EU, where it basically decimated businesses that were dependent on data. And it also, at the same time, allowed for larger companies to sort of entrench themselves because they had the means to move to jurisdictions which were friendlier in terms of GDPR compliance. So, I mean, GDPR raised a barrier of access to data. It also added a compliance cost, etc., etc. Was very burdensome for smaller companies, and so forth. So you saw the larger companies kind of win out. So that is one reason. We don't have that same context here, of course. The second reason is that basically Europe is making a bet on short-term short-term pain for long-term. What they expect is gain, even though there's no empirical evidence, definitely, and even no anecdotal evidence to support it. Where basically they want to create their own tech majors, or so their own equivalents of the US, what they dub as primarily US and I guess Chinese, because ByteDance is notified as gatekeeper there. Um, or their own versions of these companies. Now, if you have a company that is so systemically important as we have kind of dubbed it over here, then removing it or having a policy plan where you remove it completely, in my mind, is not prudent, because there is no guarantee you will be able to replicate its success. So we have a good example with the removal of TikTok in India, right? So there were many kind of copycats that came up, and basically none of them were able to uh, replicate the success of TikTok in India. Though some people argue that basically Twitter, basically companies that came out this Reels. With this Reels format, which is what TikTok was known for, basically YouTube and Instagram were able to capture that market, but there's no data to support that, and those companies already had enough of a market share, so you can't really say that it was a Reels function that they took over that market as well. Definitely no data to support it. So that is one thing. And yeah, coming back to this law, and the problem with this law is that it really considers a very narrow dimension of competition. It only considers those businesses that are in competition with large platforms, and it doesn't consider those that rely on them or have complementarities with them. So, Professor Vishwanath spoke about bundling. The other thing that I would like to speak about is targeted advertising, because there is a provision in the bill that limits the ability of platforms to use data. For targeted advertising. And while the bill or the CDCL's report accompanying it does not specifically say that the idea is to reduce the efficacy of targeted advertising on platforms, the corresponding provision in the Digital Markets Act, which is the European um, version of this bill, the recital 37 in that act specifically says so, that basically there should be no diminished quality of service unless it is a direct outcome of the restrictions set forth in that provision. Um, Now, we found in our study, like we've done some work around this, that MSMEs in India are extremely reliant on targeted advertising offered by large digital platforms for things like revenue generation, customer acquisition, cost savings, time savings, etc., etc. They are a majority of them say that relative to price, they find them easier to use and more accessible. Advertising on these platforms more accessible than traditional advertising media. So I mean, there's a lot of efficiencies that they gain from them, and so we asked them, if there was a law that came out that restricted the ability or reduced the efficacy of targeting on these platforms, how would you be impacted? And 61% of them indicated that they would be negatively impacted. And similar to what Professor Vishwanath said about bundling, we asked a question about bundling as well, because we found that 80% or close to 80% of MSMEs rely on the identification services provided by these platforms. So if you have ever gone on an e-commerce site and it asks you to sign in from Google, actually even your newspapers do ask you to sign in from your Google account, your Amazon account, your Facebook account, etc., etc. That's basically known as single sign-on. It's an identification service, and essentially the bundling restriction is a blanket one under the DDCB. And so what it would do is it would force an unbundling, and when so we asked, if and make these services more accessible, either or less accessible, sorry. And so we asked again, we asked these MSMEs, how would you be impacted by this if you were not able to access this service as easily? And they said that they would, 61% of them indicated that they would be significantly impacted. Now, the narrow frame of this law is also an outcome of the fact, perhaps, that consultations were carried out in a very narrow way, where it was largely just entities that were on two sides of a dispute. That was before the CCI. Another thing to add there, speaking of the CCI, is that none of the cases that involve these entities or involve these issues have reached finality. So that is an important consideration as well, where that the question on whether these practices are wholly and completely anti-competitive is still moot. So yeah, I think I'll stop there. But there's very little supporting the case for this law, particularly in the narrow frame in which it has been conceptualized, and of course the completely misplaced context as well.
Completely agree with you there. In fact, all the points that you raised, specifically on targeted advertising, I know at least 3,000 plus MSMEs that have gone onto the D2C space in the recent past, focusing specifically on this direct advertising or promotion that they can do to their target audience. Now, compared to that, if they were to advertise in one of the mainline newspapers, I think the company will run out of business much before they can actually even break even. So, I think it's some sort of a premature step, I would say, though in the guise of creating a fair digital market, it's actually going to create a potential hurdle for micro, small, medium enterprises or startups for that matter. I'm going to go over to Shreya. Shreya, we've discussed a lot of these possibilities. What, in your sense, is the law going to do, primarily for most of us, that are afraid of the fact that, though it is meant to create a fair market, it might actually, just limit the opportunities that we have?
Okay, so I will answer this question in a few parts and in no particular order. This draft bill has created quite a ruckus in the market overall, and I think across all categories of stakeholders, to be honest. And we do represent the breadth of stakeholders in the digital market, being a TMT lawyer. Having said that, I think the government is significantly leaning towards Europe, the EU, as a framework that it wants to adopt in India. It's an aspirational framework. Whether the Indian market is ready or not, I think it's a big question, because we do know that the economy is fairly developed in the EU. And even if you compare the quantitative thresholds that have been identified for SSDEs, there is a huge disparity, and it's very disproportionate even to what the EU market demands. So if you compare sheer numbers, there is a difference of night and day. And in fact, even with respect to users, the DMA recognizes what active users mean. We find that concept entirely missing in the Indian context. So there are a lot of these things that do come up when you're going through what this legislation is all about. Of course, there are other jurisdictions that have also been referenced, but again, I do feel India is a fairly unique economy with a lot of diverse players, and I think, unlike the EU, what is happening in India is that there are a lot of local players that are dependent on a lot of larger companies in the digital space. So there is a huge startup ecosystem which cannot and should not be ignored. Now, see, in terms of
In fact,
dependency,
before you go forward, Shreya, I just wanted to add a caveat here.
yes,
In my capacity as the board member of the World Union of Small Medium Enterprises, it's come to our notice that even in the European Union, a lot of SMEs are actually protesting the DMA, the fact that
okay,
it is stifling a lot of opportunities. So
yeah,
the fact that India is going to base its a law completely, I majorly on the EU law is ridiculous, because even constituents right there inside, small medium enterprises which are exactly using the same things there itself are not very happy with the fact that it's stifling a lot of their opportunities. And here we are in India, where we have a comparatively much more nascent ecosystem, startups, and even micro and small enterprises who are dependent on the digital economy, for their future, especially after COVID, and when we've been talking about digital transformation. And we have no qualms over admitting the fact that it is completely based on the EU thing. So back to you.
yeah. Yeah, and in fact, I mean, since you bring that up, we were in conversation with some researchers and professors who have studied the DMA as well. And of course, the DMA itself is a new law. It was only introduced, while it was introduced earlier, it was only brought into effect about a year ago. And there have, based on those conversations, what I understand is there have been some trade-offs in terms of access to technology, because just on process itself, what happens is that if a technology has to adapt itself to local legislation, there has to be a lot of thought that goes into it, and maybe there has to be a curation for that particular jurisdiction, which may not be able to give you access to all the features that a product may have, globally speaking. So I think that is one area which we can kind of look out for and expect that could be impacted. The other thing is that this legislation, I don't want to get into the details, to be honest, but there will probably be some impact on MSMEs as well, simply because as of today, there are a lot of services that larger companies that they are relying on offer to them for free, including with respect to analytics, etc., or just having access to data in a certain form and manner. Now, if the for the lack of a better word, if the ability to provide that gets significantly impacted, or in the manner that companies have been doing so far, there could be either costs associated with something like that in the future, or there could also be trickle down effects in terms of general access to what is made available and what is not made available. I think that's the long and short of it. But having said that, we are looking at a regulatory environment which is changing constantly. And from the government's perspective, I do understand that probably because technology is developing so fast, they want to try and get ahead of it. But I do feel that while the thought is good, um, there has to be more focus on the problem we are trying to solve, and there has to be more curation in terms of what kind of law we are bringing in, because uh, a copy paste approach for a market which itself is experiencing a law which is relatively nascent may not be the best fit. And I think the fact that they have reached out to the public, invited comments, I think that's a good step. It's a good step towards a consultative process, and I do hope that they do take feedback of all stakeholder classes seriously, and not just one or two.
I'm going back to Vishay. Uh, you know, uh, we just talked about the various possibilities, the impact on micro, small, medium enterprises, and the fact that it might actually stifle innovation. And the very base on which a majority of micro, small, medium enterprises have entered the knowledge economy in the past few years, especially with points like you made about things like bundling, which we are all used to in India, especially because as an economy, we're not used to paying for everything. So while you buy a cloud email subscription, you need to get a Microsoft let's say package as a package on it. It just costs you maybe a little bit of money because we don't have that much money to actually pay for a separate subscription. Now, this the framework that they are expecting to put in place is not going to be very easy for a lot of micro and small entrepreneurs. On the larger side, it might have an effect. On the medium industries, obviously, it will have an effect. There's no two ways about it. But how do you weave this overall when it comes to the potential implications of this on the entire Indian industry as a whole?
See, I think, I've been referencing this paper a lot that I read. When you do over-regulation or when you create policy uncertainty, you have several players that are going to suffer a lot more. The growth is stifled. You're looking at the data on maybe investments that are happening. Why are they as slow when compared to what we are going through? It is basically the idea that there's policy uncertainty out there, and the businesses are, in general, a little cagey when they are not able to forecast what's going to happen next. So therefore, to me, if you want to give a forecast, anything that breaks down the delicate balance of a platform is going to be harming people in a big way. Let's just be clear, right? One of the things that we notice, and I think Meghna has also pointed it out, that when firms are small, they rely heavily on digital advertisement for discovery purposes on the part of large players. Not just that, I think when we surveyed, we noticed that the smaller the firm gets, the greater is the reliance on digital advertisement for discovery purposes. Makes sense? So now the only exception to this is pamphlets, right? Pamphlets are generally for local businesses, and it seems that across the spectrum, firms are using pamphlets. But every other form of advertisement, the smaller you get, the farther you move from the traditional advertisement channels like radio, TV, internet, etc., etc. Internet becomes the more predominant one. Now, when there are restrictions on how you can do some other things that these platforms do, the price here goes up. There are restrictions that are going to form in, because ultimately you have to manage your profit margins. So therefore, what is likely to happen at the end of the day is that there's going to be greater problem on the ability of small businesses to emphasize themselves. Now, let me give you one very practical example. Right, one of my students decided to get into a startup. I had asked him, "What do you want to sell?" He said, "Nuts." And very facetiously, I happened to mention to him, "Have you gone nuts?" Because all my economics classes have been telling you that you should not get into markets which are perfectly competitive in nature. Today, he's a flourishing entrepreneur in the nuts business in every sense of the word, right? Because he's created a niche for himself through several things. Would he have been able to do it in an alternative market? Let's actually ask ourselves the counterfactual. A very simple question that I think I keep asking. Would you assume that you have problems with platforms. I'm not saying you should, but assume you have. Would you prefer the status quo with all the problems with the platform? Or would you prefer a world without the platform? Answer is stark in front of us. When you talk to my student who is doing his nuts startup, the answer is absolutely clear from his face. Right? He would rather prefer the world with platforms with all the problems, so-called problems, than the world without platform. And I find it extremely crucial for us to actually understand and ask the right counterfactual in this particular case, right? And to me, the right counterfactual is to compare the world where these platforms don't exist and what happens to small enterprises then. We keep forgetting the fact that the credibility is the most important thing that this platform brings to the table for the small businesses, and anything that hurts the credibility part of the operations, we have to have problems. I'm not saying that large platforms are completely guiltless or whatever. There are issues, but identify those issues and regulate. For example, when we did a 30 one-on-one serious chats with entrepreneurs, right? I'm luckily that way blessed to be in the place where several entrepreneurs do come up, and when we had a chat with them, their entire argument is, oh well, I hope that one of these platforms holds our hand and tells us how we can do certain things better. I mean, these guys do training programs, and here is where my students don't know about the fact that these guys do training programs. So this is a sad story, sad story or a narrative in every sense of the word, right? It makes sense for them to actually go and do these training programs more to help the small and medium enterprises. But that's the regulation. That's the part where platforms have a lot of role to play in terms of improving their association with small and medium enterprises. There's no question, and I'm sure as the president of SME Forum, you'll agree as well. I hope I got your title right. But nonetheless, I'm pretty sure you agree where these platforms can do better in terms of their collaboration with SMEs. This part, unfortunately, is not something that I'm seeing. The other assumption that we keep making is whatever is the default given to us, we swallow it with no questions asked. Oh, I'm sorry, I don't agree with that at all. I mean, I think we are voracious for new. We have voracious appetite for new stuff. We love new stuff. We download stuff like crazy and we delete stuff like crazy. So therefore, will default actually harm me? I mean, how many of us use, GPay versus Paytm? GPay comes pre-installed, Paytm maybe not. I mean, how many of us use exactly what is given to us without exploring other options? I mean, we're a country of jugaad. Yeah. I mean, so therefore, we do look for other options. So therefore, these are the set of assumptions which could be dangerous as far as small and medium enterprises are concerned, because they are playing a role in the development of small and medium enterprises. So therefore, maybe it's time to understand: are we killing the golden goose, or are we, or are we throwing the baby with the bathwater? I mean, you tell me 10,000 cliches, and I'll come up with another one more that will fit this entire story. But that's pretty much what it is, right? So I'm a little. Maybe long and short of it is that I'm a little skeptical about the advantage to the small and medium enterprises at this stage. I think we are fine. We are still looking at it from the point of view of without having local data in mind. Maybe I'll stop here.
I'm going to go over to Meghna. Meghna, we're talking about the international landscape for ex-ante regulation, in digital markets is still in its infancy, I would say, with few precedents. You have countries like Japan, Singapore, which are reconsidering their stance on planned ex-ante regulations. And I think there's need for a cautious approach. Again, because, there's limited history of this ex-ante regulation and its uncertain impact on market dynamics and actually enforcement of competition, laws. So what is your perspective? Internationally, should we be seen as a country which is going to go back to the time when we had the MRTPC Act and the associated pedophilia?
Yeah, actually, while discussions were going on earlier, I just wanted to do a little dipstick just to see, and this was kind of the inspiration behind our study for evaluating the impact of targeted advertising on MSMEs. I just scrolled through Instagram for 30 seconds, and through those 30 seconds, there were 11 brands, all Indian, all small, and all primarily online, that were shown to me that were of interest to me. And I mean, the counterfactual, I mean, the point being that without targeted advertising, I would not be able to access those brands and they would not be able to access me. Going to what you are saying, yeah, I mean, the DMA is an extremely experimental uh, uh, legislation. We've already seen that Europeans are first movers in regulation, and they kind of pride themselves on regulatory innovation, but that doesn't mean they get it right.
Very correct.
And they didn't get the GDPR right. There's a lot of there's a lot of mixed opinions even within Europe about the EU AI Act. Even on the DMA, there were some mixed opinions, but perhaps not as much. But if you see the work of European scholars, a lot of them say that there is going to be inconvenience for consumers, there is going to be inconvenience for small businesses, etc., etc. And yeah, we have to also see the example of other countries, particularly the US, which might be seem very hawkish in its rhetoric, but ultimately is not going to pass any form of legislation. There's tons of bills that are waiting in the wings in Congress, but I don't think they're going to see the light of day. You may see a lot of ex post action. You're seeing, um, new cases being filed against larger companies every day over there, and the DOJ recently filed one against Apple. But you're not going to see the passage of a law because ex ante is so rigid, and particularly these broad kinds of prescriptions. And as Professor Vishwanath said, this one size fits all approach where it's not even about different markets, but it's also about considering a market context, and not even a situational context. And that is something that only ex post can resolve. And because you have to, there has to be you have to adduce evidence, and the regulator has to understand the market and how it operates. And I'll give you an example. There's been multiple situations, or there are situations where a particular practice has been deemed anti-competitive, but because the entity, there is no way for the entity engaging in that practice to do its business in any other way. There's It's kind of reached an impasse. Like, either that entity exists, or you find it. Either it exists or it doesn't exist, and you find the practice, you prescribe the practice, and the entity does not exist. And again, that entity is vital to a particular market ecosystem. And I think all these things have not been considered. I think that it reads like a rushed job, even though they had a year. And it's even if there are practices that are problematic, that are prevalent, there is um, nothing to suggest that the um, existing mechanisms in place uh, are not well equipped to address these issues. And a lot of it is about understanding what the issues are at their crux. So, transparency, I would say, is a big one. There's a lot of the problems highlighted are related to information asymmetries. So I think that is something that would be simple to do through the form of disclosures or labels, and it would kind of do away with a lot of the unfairness that is being alleged on the part of larger platforms.
Cool, thank you. And I'm going to go over to Shreya. Shreya, you represent a lot of enterprises that are global multinationals in the technology space, telecommunication space. Um, what sort of an approach would you like India to take specifically when it comes to this act? What was the changes that you would like to see? Um,
See,
uh, Apart from the fact that obviously there'll be more stakeholder consultations and they'll take in a lot more
yes,
perspective
yes.
comments from people.
So that's a fairly loaded ask. But I will say this. See, a lot of what the bill is trying to cover, in a way, does also get taken care of in the existing legislation, which is the Competition Act. And I think that was one of the general bigger questions about whether a separate law is needed, are regulations sufficient, to supplement the existing law. But I think, like, however things have panned out, a decision has been taken that uh, we need to at least see what a bill in this space would look like. Now, having seen that, one does question whether it is trying to achieve more than what has already been prescribed. And secondly, in doing so, whether okay, let's take, for example, the definition of SSDEs itself, which is systematically significant digital enterprises. Now, of course, there are certain quantitative and qualitative parameters which have been prescribed. But in addition, if you see what dominance means under the Competition Act, the same principles have been kind of captured in the qualitative aspects also, on qualitative parameters. So it seems as though, in addition to a finding that just by being dominant, one could also qualify as an SSDE, regardless of anything else, just because of the sector you operate in. Because you have a digital presence, you can qualify as an SSDE. Whereas, it does lead one to wonder why not the same approach across all other sectors. So I think that is a primary question that one may want to ask, because if you look at the number of competition cases, yes, there are some ongoing in the tech space, but there are also many cases of similar nature, similar allegations, if not the same, but in, of course, their own relative context going on in other sectors also. So what distinguishes this sector for which a special legislation is required? I think that's one question which the legislation itself has not answered. I think there is a enabling provision to bring in certain additional core digital service related compliances and obligations, but unless we see that, there is little merit in what is currently being put out. And I think even if you read the enforcement structure, the way that the draft bill has come across, it is very, very similar. And, one wonders why it is exactly the same. There's no special committee. There is no, I would ideally prefer if something like this was coming in. Of course, there have to be many provisions that have to be diluted significantly. Parameters need to be reassessed, and we are ourselves also, putting in some comments for the consultation process on behalf of some of our clients. But that aside, I think the CCI could definitely benefit from a committee of industry experts that really understand the space, and can guide on a case by case basis, because I think we've discussed this today and on many occasions prior, that one size will not fit all. Like, even for example, even the recognition of who SSDEs are, does it apply uniformly across all the core digital services listed out, or do different considerations have to be met for different kinds of services and sectors? Because where you're talking about business users, you're talking about end users. I mean, everyone's business needs are different. So why is a context, why is the parameter of active users not coming in? Why is the concept of transacting users not coming in? Because there could be platforms where people are just browsing, but maybe people are not purchasing. So how do you kind of differentiate those aspects as well? And yeah, those are some of the main issues I feel that should definitely be thought through and addressed, if at all a legislation has to be brought into the space. I mean, that itself, right now, I feel that there is a lot of work that is needed in any legislation that comes in here, if at all it does.
Excellent. Thank you very much. In fact, I am going to go back to all of us and figure out any of us have any closing comments before I close the session. And then I can also take some questions which people have. But I think most of the questions that I had here from the journalists here, as well as the participants, we've already covered, except maybe one or two questions which are not very relevant to the topic. But if I have time, we can take them. But I'd like to go to each one of you for closing comments before we go to the questions. Rishi?
Yeah, I think I teach how firms compete a lot in my class. So one of the things that we keep ignoring, and I've created this character, and this character is available pretty much everywhere in every gully in India. The name of the character is Chotu. Chotu will run errands for you. Chotu will clean your car. Chotu will, basically do small stuff for you. And Chotu will also get you that masala dosa from the street side restaurant if you really need it. Or if one of the taxi cab companies shows off too much, the Chotu will also drive your own car, come to airport to pick you up. So therefore, the real competition in India actually comes from the informal market, the SME market. even to the big players. I think we have to be very clear. So therefore, this is what I'm trying to say here, that small enterprises are also a competition. Small enterprises also use digital markets. It's a very interesting and powerful collaboration between both of them. I mean, they fight and they compete and they love each other. I mean, so that's a kind of a symbiotic relation that exists. I don't want to use the word synergies coming from a business school. It's too much of a cliched word. But nonetheless, you get exactly where I'm going with it. This Chotu is a very ignored player in the Indian market. So therefore, when you're looking at it, competition from the informal sector will have to be considered very, very, very seriously when you're passing any regulation. That also answers the question on whether something is dominant. When you're doing market definition, you can be a monopolist for a given market, and you can also be in a perfectly competitive market. I mean, so therefore, you have to be very clear and careful about that, and that's something that a regulation ought to keep in mind. I'll stop there. These are my closing comments, if you will.
So we go over to Meghna.
Yeah, so just in terms of justification for this law, first of all, it doesn't even seem to catch dominant, I would say per se dominant players, but really if you're just moderately successful, I mean, 10 million users and 10,000 business users is not a very, very sizable entity in the context of a digital market, any digital market. So this law seems to indicate that if you are moderately successful in the digital markets identified, also it's created advertising services is a separate core digital service. So technically, on a very broad reading of this law, if you provide an advertising service in tandem with something else, which is what a majority of Indian businesses do, because that is how the Indian market is, you cannot do that anymore. So there is no rationale there's no ability for your business to exist, because you cannot bundle advertising services with your service, basically. But my point being, there's not enough basis or rationale for this law to exist. Even the CDCL report does not seem to provide it. What they have said is that basically it is needed because ex post is too slow, and it takes too long for cases to reach finality. But really, if you consider the scope of this law, you're talking about multiple digital markets, and you're talking about one regulator that has to, in addition to this, do all of its other, carry out all of its existing obligations. So you're looking at a huge backlog in terms of, and has to carry out all its existing obligations, and also then decide what is integral to each digital business that qualifies as an SSDE. So it'll have to be a negotiation, which will take multiple years. Then, of course, once that negotiation concludes, or that deliberation concludes, you can be rest assured that there will be litigation, because it will definitely impinge on the ability of a digital platform to do business. And this is a cycle that will ensue with nearly every, I'm pretty sure all digital entities that fall under this. And so you're not looking at a process that will conclude, speedily or efficiently. You're looking at maybe a 10, 20, 15, 25-year process. So where is the efficiency there, and how is that better than ex post? In my opinion, it's not. So yeah, I mean, I think there's limited to no justification. We don't know how the DMA is going to play out. We're already seeing in Europe that it's making services more expensive and inaccessible. So again, it has led to a dispute between the European Commission and I think 3 or 4 companies. So there is no finality to it, and the point of regulation is to solve for market failure, not to create it. And we seem to be hell bent on following the example of other jurisdictions, even where they have created market failures. I mean, I think the evolution of our data protection law is a perfect case in point, right? We started with something that was basically a replica of the GDPR, and we then moved towards a framework that was crafted to suit the needs of our market, or to the context of our market more specifically. And I'm not saying that we do that here, because I don't think there is a rationale for any law that interferes in the product design on the operations of the way a digital platform works. There is no way that it will not yield some kind of market failure or the other, particularly if you're talking about something that is so systemic to an ecosystem. And that's where I'll conclude. Thank you.
Excellent. That was really to the point and all encompassing. Thank you very much for these comments. I'm going to go over to Shreya for her closing comments.
So, not too much to add based on what has already been said, but I think the one thing I would like to reiterate is while this appears to be a draft taken out in the name of what is considered ex ante legislation, but the fear is that a lot of the ex ante provisions or obligations are left to the additional codes of conduct that will be provided for different kind of core digital services. And what we see in this legislation is essentially, or this draft or the proposal for the draft is essentially just um, an identification parameter followed by enforcement, which, as Meghna also pointed out, is very, very similar to what the CCI requires, other than, of course, the negotiation and settlement provisions. But even they do exist in some informal form as far as CCI is concerned. But the regulator remains the same, the expertise remains the same, and the caseload will probably increase. So I think, yeah, just to conclude, there has to be a lot more thought that goes into this for a market like ours. And definitely the kind of thresholds which are suggested do not work, especially because our population is much more. The digital users are very, very significant as compared to any other market. And even in the EU, while it is central legislation, different member states implement it differently. So I mean, we have to really look through what works for our market and what doesn't.
Thank you very much, Shreya. For the benefit of people that have joined late, we were discussing the draft digital competition law, which has been put out by the ministry further to the Committee on Digital Competition Law, set up in Feb to examine the need for an ex ante regulatory mechanism for digital markets in India. And overall, I feel from where I started and where I'm now, I generally am feeling that this draft digital competition bill unfortunately had limited involvement of MSMEs or MSME bodies in regulatory discussions, and which essentially could mean that this draft law could lead to regulations that do not fully consider the synergetic relationship of MSMEs with digital platforms. And my personal opinion is also that as of now, the way the digital draft competition bill is put out, it is threatening to disrupt this very symbiotic relationship between MSMEs and large digital platforms in the context of India, the way we see India today, and the way we see digital platforms operating in India today. Most of them to the benefit of micro, small, medium enterprises. With that, thank you very much for your time. To Rishi, Meghna, Shreya, it was wonderful. I've learned so much today, and I look forward to having all of you again very soon on another topic, or maybe the same topic for all you know. And we hope that the government will relook at this entire thing and go back from being a highly regulated digital economy to the way we have functioned all these years in the context of also becoming a 5 trillion economy. Thank you very much, and good evening and good night.
Thank you
Thank
very
you
much.
so much.
Thank you. Thank you.